having in mind that the offense will which the accused person is charged with is bailable, as stated by the counsel for the accused person. It is also noted that the bail is not automatic, as it is bailable. It is at the discretion of the court, either to grant bail or deny bail. That is entirely at the discretion of the constitutional court. But the discretion is supposed to be exercised judiciously. The court has to take into consideration when granting bail the public interest. But the public interest also demands the accused person to release on bail. Once we talk about the offense with which the accused or applicant is charged with, bailable, yes, it's bailable, but it's also serious in nature. And that one has been read and is known. It's a serious offense, which affects actually. Can even affect the entire country. It affects the public. Much as it's presumed innocent. They're not condemning that it's already guilty, but that's the fact. The council also cited the uncertainty as to when this matter will be tried as one of the grounds that the applicant should be granted bail. I wish to remind the council that when the accused person appeared in the court, he already informed the court that the inquiries were complete. This matter was not fixed for hearing, basically because we were out of time, and today it was fixed for bail application. Counsel for the accused person tried to apply for bail, but due to time, it was fast. That does not mean that the inquiries are incomplete. Prosecution is actually ready to proceed with this matter and have it handled expeditiously. So that one should not be a factor for the applicant to be granted bail. The council also stated before the Senate Board that the applicant has a fixed place of abode. I wish to inform court that this applicant, when he appeared before the police officer, the first thing is to establish his place of residence. And he stated that it's a resident of Chanja, that is in Akawa division, captured in the charge sheet. And that one was his first full particulars, and also gave his phone contact in regard to that. But today, council has come up with another contradicting information in regard to the resident of the applicant, saying that the applicant is a resident of Lusaka village. Urban Council, in marking division, different division now from Nakawa to marking, that's I don't know when he's shifted, but now he's in marking division. So also this alone raised the issue of doubt as to whether the applicant has fixed place of abode. It is in doubt created by the applicant himself or the lawyer. But the fact remains that applicant's fixed place of abode is in doubt. I pray that court will take into consideration that when granting bail. Then the first surety for the applicant is said to be the mayor of this division. A mayor is somebody who owns duty to reach subjects, being it the complainant, being it an accused person. The mayor owns duty for them as their mayor. So there is a conflict of interest. Mayor, as a surety, may fail to discharge his obligations because his interest will conflict. He has the complainant who are also his subject. The accused person also is a subject to mayor. Mayor is the head. In local, we even say the mayor is the president of that division. Local people conceive it in that way. So the interest of the mayor will conflict. You can't say they support the accused side. Go the other one. They are also yours. How will you handle it being the mayor or the division? That's the issue to be taken into consideration. In that circumstance, I feel that the mayor should be inform, not substance or that's a duty for an accused person. Reason being, he also owes duty for the others who are the side of the complainant. It will conflict. Then they do sureties, also tendered by the accused person. These are the sureties that each person produces them by their just friends. They are friends. So in an event, yes. But they tell the surety. They tell the surety is a friend. That's a friend. As I've mentioned. So in an event, the accused person happen to jump court bail. He may fail to discharge his duty as a surety, which the counsel for the accused person informed the honorable court that they were being taught of their duties as a surety. But to me, he may fail to discharge. This duty being a friend may not be able to trace the accused person, the event that this person runs to the village. How will he trace the accused person? He may fail. That's a friend in the city. He will fail. So on that ground, Your Worship, and for the interest of justice, it's my humble prayer that this bail is denied, the matter is fit for hearing, and it's handled, and his faith is determined. If he is found innocent, find guilty, the faith is determined. I so pray Your Worship.
Can you briefly join Your Worship? We have not contradicted the prosecution as regards whether the inquiries are complete. What we have stated, Your Worship, is that we are uncertain as regards when the trial will commence. We are also uncertain as regards when this matter will be concluded. Why should he be kept in jail when there is a possibility of him being found to be innocent? And indeed he pleaded not guilty. Your Worship, my land sister for the prosecution has submitted to the effect that there is contradiction as regards the residence of the applicant before you. But there is a requirement under the bail guidelines that every applicant should have an introduction letter as regards to his residency. The framers of those directions were aware that the prosecution normally indicates on the charge sheet the residence of the accused person. Why would it be required again for one to have an introduction letter? The accused person is at liberty to contradict the findings of the prosecution. Your Worship, on the court record, there is a letter by the local council authority confirming the residence of the accused person. And that residence is within your jurisdiction, Your Worship. Being Lusaka village in Machinde division, Kampala. Had we cited the information in the charge sheet, my sister would have objected, saying that they have not produced an introduction letter from local council authority. The information on the charge sheet, Your Worship, is a subject of scrutiny by this court. And that will come at trial, Your Worship. And that is information from the prosecution, not the accused person. Because the prosecution has as well confirmed that our client is a resident of Machinde. When she raised an objection against the mayor, Ali, being the surety, one of the sureties, saying that he will contradict his interest in regard to the complainant and the accused person, since both are his residents in Machinde division. That he owes a duty to both. Your Worship, is that a clear indication that the accused person is a resident of Machinde? As regards the mayor having a challenge of contradicting interest, Your Worship, my land sister for the prosecution has not cited any connection between the mayor and the case before you. is not one of the witnesses or potential witness. And you worship that the person is still innocent. There is presumption of innocence which he enjoys. Should the mayor be judgmental at this stage that this person is likely to be found guilty at this stage? My land sister is stretching beyond the limits. I invite you to reject that objection. Lastly, Your Worship, my land sister for the prosecution has stated that a friend being a surety, that he may not execute the duty. That is speculative, Your Worship. There is no proof in that regard, Your Worship. He's saying he's likely, he may not, but that is speculative, Your Worship. And Your Worship, a court should not rely on such baseless objection to deny that the person bail. Where the law does not define the relationship, which kind of relationship that must exist for one to be a substantial surety. In our practice, Your Worship, friends have been standing as sureties for accused persons. In that regard, Your Worship, I invite you to ignore and reject the objections raised by my land sister for the prosecution, grant bail to our client on lenient conditions, yes, we agree that a bail is not automatic, but Your Worship, the constitutional commandments are clear that when the needful has been done, including presenting substantial sureties, as we have done here, court may exercise its discretionary powers and grant bail. We pray that you invoke your powers as provided for under Section 76 of the Magistrate Courts Act and grant that bail. We so pray, Your Worship.